Good morning. Before we start, just an administrative procedural question. We will start with Mr. Mander today, and then we have Ms. Gunsman. If we were to finish with them today, the next expert, Mr. Flubacker, would be available to continue today.
Good morning, Mr. President. Mr. Flubacker is currently scheduled to arrive from Delaware at noon, so he should be able to start after the lunch break.
Okay, great. Thank you. Thank you so much. Any issues the parties would like to raise before we start? Claimant?
None from claimant side, Mr. President.
Thank you, Mr. Wicken. Respondent?
Nothing from us, Mr. President.
Thank you. Can we call then Mr. Mander for his declaration? Good morning. Can you please turn your mic on, please?
Is that clearer?
Yeah, that's perfect. Good morning, and please, for the record, can you state your full name?
My name is Henry Christopher Mander.
Thank you. And you have a declaration in front of you?
Yep. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Okay. Claimant, you have the floor.
Good morning, Mr. Mander. Could you introduce yourself and tell us a bit about your experience?
Yes, thank you. Good morning. My name is Henry Mander, and I am a partner at Harney, Westwood and Regals in the Cayman Islands. I am the global head of their private wealth practice. I was admitted as a solicitor in England in 2003. I worked for two well-known law firms in London that practice the area of private client law, Farrer & Co. and Boodle Hatfield. I moved to Harney's in early 2011, offshore, originally to the British Virgin Islands, where I was admitted in January 2011, and then I moved to Cayman in August 2011, where I was admitted that month, and I have been practicing BVI and Cayman law, primarily in the area of private wealth and trusts since then.
Thank you. There's a copy of your report. I don't know if you have one in front of you. If not, there's one behind you of your report, not the presentation. Yeah. Okay, great. Could you flip to the last page?
Yes,
Could you verify that that's your signature?
it is.
Okay. Do you have any edits or corrections you'd like to make to your report?
Yes, I have two corrections. One is in paragraph 4, spot 14, Roman 6, where the reference should be to Article 120 instead of 121, and in paragraph 5:12, where the reference right at the end of the second sentence, it should be to Article 85 rather than Article 50, and the cross-reference where it says as described in, it should say 511 instead of 5.7.
Thank you. Mr. Mander, you were present yesterday for respondent's opening statement as well as Mr. Lindley's presentation, correct?
I have a question for you, sir. It's the same question I put to the other expert. We are hearing a lot about control. According to your presentation, Cayman Island law is based on a statute, the decisions of Cayman Island courts, which I understood are more or less in sync with the English common law. Is there a notion of control that can help us to understand all of this, or control is just something that we have to see as a fact?
Yeah,
Just look it as a fact.
Yes, it's not specifically defined. We're looking at both corporate and trust analysis here. Trusts split legal ownership and beneficial ownership. So, it can be stated that JP Morgan was the shareholder of Travis PTC, but that's of no consequence because they don't have any beneficial ownership. Plus, if you look at the actual practical effect of the documents, which is how you analyze control, you have to look at the totality of everything. So at every level, nothing could be done in this structure without Mr. Pellis's agreement. That's very clear.
So it's an issue of fact.
Yes.
Okay, thank you.
Thank you, Mr. President.
Respondent, you have the floor for cross.
If I could just have 5 seconds to confer with our expert, but it wouldn't be more than 5 seconds. Thank you. Can you hear me okay? Thank you.
Any questions in redirect?
No questions from claimant.
I am a little bit puzzled when you refer to ownership. That is limited to real rights, or you can also use the notion of ownership in connection with personal rights. I assume that the differentiation between real rights and personal rights are part of the Cayman Island law.
Yes, they are, but I think they're slightly different from the analysis of ownership. I mean, ownership, you really have legal and beneficial ownership. So legal ownership, in the case of a trust, would be with the trustee, and beneficial ownership would be with the beneficiaries, or, they have limited beneficial entitlement. So under common law, we have split ownership possibilities, yes. But that's a separate thing from control.
That's not my question. My question is really, when you talk about ownership, you only refer to real rights, or it's also, if you have a title, you're entitled to exercise a personal right. Is that also covered by the notion of ownership under Cayman Island law? Do you understand what I'm saying?
So if you have ownership, you would look primarily for legal title to who owns something, but then if there's a trust behind it, then obviously the trustee is not holding the asset for themselves. That asset doesn't appear on the balance sheet of the entity that is the trustee, and then beneficial ownership must be analyzed through the trust. Your question, you're asking about personal rights. I'm not sure the context of that.
Contractual right.
I'm sorry, your question again, please, sir?
A personal right, for example, is a right under contract. You can exercise a right under contract. Is that ownership under Cayman Islands law or not?
I don't think there's any specific law on that.
Okay, that was my question. Thank you.
I contribute assets to a trust under Cayman law. The ownership, who's the owner of the assets? The
Legal
trustee.
title is
The
with
legal
the trustee.
title,
Yeah.
The trustee.
Yeah, because the trust doesn't have legal personality of itself, so the trustee always represents the trusts in terms of being the owner, the legal owner, yes.
And the general rule is that if I do not reserve rights, then all the rights on the assets are rights of the trustee.
Well, there's a distinction between rights and powers, because a right is typically something that you can exercise in your own interest, whereas a power is, a fiduciary power is something you have to exercise for others. So yes, if you have a normal Cayman trust without any reserve powers, say you created a trust, you transferred a company to a Cayman trustee, then that Cayman trustee would be the legal owner, and it would have to deal with its shareholder rights as a fiduciary for whoever you chose as the beneficiaries of that trust.
So I would only have those rights that I reserve in the trust. Is my understanding correct?
Yeah, if you didn't reserve any rights through the trust, once you've transferred the asset away, it's for the trustee to decide how to administer it. You might be a beneficiary of the trust, so you might have separate rights as the beneficiary, but as a settlor, if you don't reserve the powers to yourself in the trust instrument, you've
So if I do not reserve the right to administer or manage the assets, then the right would be vested on the trustee.
Yes. Yeah. I mean, administer and manage is a different concept, and you also need to consider who the trustee is. If you're transferring it to a PTC that you're a director of, that's fundamentally different to transferring the assets to an independent third-party corporate trustee.
Okay. Okay, thank you very much, Mr. Mander. This takes care of your testimony. You're now free to go. We're going to take the break now, 15 minutes, and move on with the next expert. Yeah, 15 minutes. Good morning and welcome. Can you please, for the record, state your full name?
Isabel Santos Kunzman.
Thank you, and you should have a declaration in front of you. If you
I
can.
do. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. Respondent, you have the floor.
Thank you, Mr. President. We will not be doing a direct. Ms. Guzman would go directly to her presentation. And we just wanted to note that we tried to circulate her presentation by email, but we were unable to do it. But we have provided hard copies of her presentation to the tribunal and our colleagues on the other side. And as soon as we can, we will circulate the presentation by email. Thank you.
Please go ahead.
Great. Before I go into the details of my opinion, in this slide, I present an overview of my qualifications. I am a partner and managing director at Alex Partners and co-leader of its international arbitration practice. I have an MBA with the highest distinction from Georgetown University and over 26 years of experience in finance, economics, and business administration. And since 2004, I've been working exclusively as consultant on quantum matters and arbitrations and domestic regulatory proceedings. I have worked on over 45 international disputes and over 25 investor state arbitrations, and I have testified on behalf of claimant and respondent almost in equal proportions. Now, in this case, I was asked to perform three things. First, to analyze and graphically summarize the ownership structure of Campos de Pesé as of three dates, which I refer to as the relevant dates: June 1st, 2011, the investment date; the alleged breach date of August 30th, 2014, and the claim date of May 4th, 2020. Second, I was asked to identify the relevant entity's board of directors. And then third, I was asked to review selected claimants' claims. Now, to analyze the chart and ownership structure of Campos de Pesé, I performed 6 steps. First, in charting and analyzing the ownership structure, I was asked to do it in relation to the identified Italian individuals. These are individuals that claimant identifies in their counter memorial as being Italian. It is in dispute whether some of these individuals are Italian. So when I refer to Italian individuals in this presentation, I'm referring to those that claimant identifies as Italian individuals. So first, I identified the Italian individuals and determined their shareholding in any of the structure, direct shareholding, which in this case was for the company SER, which is below Campos de Pesé. I then reviewed the relevant entity share registries. So, for example, the SER registry as of June 1st, 2011 lists Bengal Investment Management Corp. As holding SER shares on behalf of Leonora del Carmen Solorzano. So then I went to the Bengal Investment share registry and determine if Leonora del Carmen Solorzano figure in that document and what number of shares she held. So for most of that analysis, I was able to rely on the relevant entity share registries, which I submitted my report. Then I had to standardize names. Some of the entities changed names over time. Some individuals used a different number of last names. So I had to standardize those. I then determined the relevant entity shares outstanding and board members. In most cases, I was able to rely on the share registries of the relevant entities. And I assume, unless otherwise noted, that the shares outstanding were consistent throughout the 3 dates. And in some instances, I actually had to rely on the actual shares issued. Then for the board of members, I relied on either board minutes or also the share registries that contain the list. I then defined groupings based on 8 groupings that at the direction of council. And finally, I calculated the ownership percentage of each Italian individual's direct and indirect ownership interest from a financial perspective of Campos de Pesé based on various combination of groupings, which I provide in the appendix to this presentation. I can't. Okay, got it. Yeah, okay. So claimant does not dispute my calculations or methodology. As you can see in this quote, they agree that the math is correct and that as of August 2014, the Italian shareholders had an indirect ownership interest of only 45.8% in Campos de Pesé. So Italian nationals own less than a majority of Campos de Pesé. In this chart, I provide claimant's view of the ownership structure. So as you can see, the Italians, individuals, only own 46.86% of Campos de Pesé, and non-Italians 53.14%. So everything that we just heard about the trust and all that, that would fall under the Italians. So even if you include the trust, you don't get to over 50% ownership for Campos de Pesé. Now, there are 5 areas of dispute for August 30th, 2014. The first one deals with Campos de Pesé, SER Corp's ownership in Campos de Pesé. Claimant assumes it is 91 and change, and we identified that it only owned 90.35%. So based on that ownership, I put in this chart the areas of agreement and areas of disagreement between the parties. So as I mentioned, both parties agree that non-Italian ownership interest in Campos de Pesé as of 2014 was 53.78%. That is the minimum that they agree on. Then the Italian individual's ownership at 9.10%. That is the direct ownership interest. Now, the areas of disagreement, as you have heard, deal with the trust entity's ownership interest. Then the BVI, Nicaraguan, Panamanian entities' ownership interest. Then the Liguria Holdings ownership interest, because the passport for Rogerio Palacio, who is the owner of Liguria Holdings, expired in 2005, the one that is in the record. And then the issue with Silvana Solorzano Payas, because as she states in her affidavit, she only owned shares in SER after 2018. So for May 2020, there isn't a dispute of how much SER Corp owned of Panama Sugar States and in turn Campos de Pesé. The only areas of dispute relate to the trust and the Nicaraguan BVI and Panamanian entities. So, in conclusion, the SER Secretary documents do not accurately represent the Italian individual's ownership of SER Corp based on the issues that I mentioned and additional ones that are in my report. In this presentation, as appendices, I've put in the 2011 areas of disputes and more details on the issues that I brought up regarding, for example, Silvana, and then the specific Italian individuals in case you need them. And with that, I conclude my presentation.
Thank you very much. Claimant, you have the floor.
Thank you, Mr. President. Am I loud enough?
Yes, thank you.
Okay. Wanted to confirm. Good morning, Ms. Kunzman. Can you confirm that you have a copy of your report in front of you, or otherwise at least able to see the screen there?
Yes, on both. Yes.
So as I put questions to you and I put documents up on the screen, you can follow along. Now, Ms. Kunzman, you opine on the ownership structure of Campos de Pesé, correct?
On the ownership interest that the Italian individuals hold in Campos de Pesé.
Okay. And you are primarily a valuation expert, are you not?
Yes, valuation, financial expert, and business management.
Okay. You do have a master's of business administration. I saw that in your
Yes.
CV. But you're not an attorney, correct?
I am not an attorney.
Okay. I think as we begin, it will be useful to sort of review some terminology. And I'd like to just turn to page 6 of your report, where you lay out the categories that you've divided all of the shareholders into. You can put that up.
Yes.
Okay. So your first category, you have overall 8 categories here. Oh, sorry, can we, there we go. Okay. You have overall 8 categories here. The first is A1, the Italian SER shareholders. And those are those people that own shares directly in SER Corporation, correct?
Correct.
Yes.
They have a direct ownership interest, yeah.
And then A2 are the indirect shareholders of SER Corporation, correct?
Yes.
And you note elsewhere in your report that category A2 encompasses some of the other categories below, such as category B, firms with majority Italian ownership and a majority Italian board, correct?
No, they're separate categories.
Okay. Category C then is firms with majority Italian ownership but minority Italian board, correct?
Correct.
And then category D, firms with disputed Italian ownership. E, trust entities and entities with incomplete ownership documentation. And then F, firms with minority ownership.
Correct.
Okay. And you collectively refer to the firms and entities that comprise categories B through F as the relevant entities, correct?
Correct.
And the relevant entities also include then Panama Sugar Estates, the SER Holding Corporation, and Campos de Pesé, the claimant, correct?
Yes. I define them in my presentation, yes, as that.
I'll also refer to the organizational charts that you submit as Appendix 4 to your report and Figure 3, which is your table of the ownership structure, as your model. Does that make sense? Okay.
Yeah.
In preparing your model, you reviewed the corporate documentation of each of the relevant entities, correct?
Correct.
And by corporate documentation, I mean that there is a consolidated exhibit file in the record that contains the company's legal governing documents, its share registry, its registry of members or register of members, and the passports for relevant individuals, correct?
Correct.
Did you request those documents or were they provided to you by counsel?
They were provided to me by counsel.
Did you have access to the entire case file or just what you were given?
I had access to the entire case file up to a certain point. So, for example, for the trust entities, I understand that some documents were provided later, and I did not look at those documents in detail because they didn't change my opinion.
So the documents that you refer to in your Appendix 2, and in Part 2 of Appendix 2, as documents in the record, are those only the documents that you reviewed or only the documents that you refer to in your report?
Reviewed and referred to in my report. If I had asked, I could have gotten more, but those are the ones that I reviewed.
And so were there other documents that you reviewed that are not reflected in that table?
I don't think so, no.
Okay. If we could look, or before we get there, actually, when you reviewed the corporate documentation, your focus was primarily the share registries, correct?
Correct.
And you performed your calculation of share percentage based on what was reflected in the registry, correct?
Yes. Yes.
We'll get into that in a moment, but first, and I believe you mentioned this already this morning, that you also reviewed the register of directors of each company, correct?
Yes, and there were some exceptions, right, as I mentioned in my presentation.
Yes. You did not review the provisions of each document, each corporate sort of set of documents that related to corporate governance, correct?
Correct.
So you did not review or analyze the rights of shareholders or directors in the companies?
No.
In preparing for your presentation today, you did review claimant's rejoinder, correct?
Yes.
Did you review selected portions of it or the entirety of the document?
Portions that mention my name.
Understandable. And you also reviewed the document marked C0204, which is claimant's model, correct?
Do you refer to as the PowerPoint with a, yes.
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 And you had previously reviewed claimant's counter memorial, correct?
Parts of it.
In your access to the case file and in reviewing those documents, did you research or review the reports on BVI law, Cayman law, Nicaraguan law, Panamanian law?
No, no.
So you do not opine in your report or your presentation on who controlled each of the entities, correct?
Correct.
Okay. And in fact, when you say then that Italian shareholders do not own the majority of shares, you don't intend that as a legal conclusion, correct?
Correct. It is from a financial perspective.
Your report states that you created the 8 categories of shareholders that you use at the direction of counsel, correct?
Correct.
Did you devise any of those categories yourself?
No.
Did you name them?
No.
Do you attribute any significance to the use of the terms firm or entity in the titles of the categories?
No.
And categories B and C differ really only on the nationality of the members of the board, correct? B being majority Italian, C being minority Italian.
On whether they were identified Italian individuals by claimant and whether those identified individuals were majority or minority. I know that some of the terms are in dispute here, so.
Yes, of course, but just the major difference between those categories is the composition of the board.
Correct, correct.
Did you assign in your report any significance to the nationality of the members of the board of a relevant entity?
No.
And in fact, when you construct your model, you include categories B and C equally in the ownership structure of Campos de Pesé.
Yes.
And in doing that, you did not differentiate between those two categories, one being more ownership than the other?
No.
Your calculation of the ownership did not include categories D and E, correct?
What do you mean by calculation of the ownership?
That's fair. If we could put up paragraph 27 of your report, and you have that in front of you. Here you note that you excluded category D. Actually, I'll wait for it to come up. Okay. In paragraph 26, you say, the org charts presented in section 5 in appendix 4 consider groups A1, A2, B, and C in calculating the Italian individual's ownership of SER Corporation and by extension Campos de Pesé. Did I read that correctly?
Yes.
You then state that in my analysis, and this is in paragraph 27, I do not consider the relevant entities in category D as Italian. Correct?
Correct.
And you go on to say, because you could not determine whether the Italian individuals had majority ownership of the shares of those entities, correct?
Correct. Yeah.
And likewise, if we could go down a bit more here. You state that you excluded category E as well. And it says, I do not consider the relevant entities in category E because they lack sufficient documentation or are ultimately owned by trusts, correct?
Correct. So the documentation that I saw ended up in another entity, and I didn't know who the shareholders of that entity were. And then for category D is the issue with Rogerio Palacio, the passport that had expired in 2005.
All right. So to sort of paraphrase, and you should tell me if this is correct. When you say incomplete ownership documentation, what you meant was that you don't know who owns the trustee, and so you could not follow the chain all the way through. Is that right?
Exactly. Yeah.
Were you instructed to disregard categories D and E in your model?
I'm not sure I understand what you mean by disregard. As you can see in figure 3, I provide to the tribunal a table with all of the potential scenarios that they could use, adding all of the categories or just some.
I'd like to look at some of the assumptions that allowed you to put shareholders into some of these categories. And I think what would make the most sense to me is to just take you to the table of contents where you list out the steps in order.
Yes.
But you have the full report if you need to look in detail at what the steps contained. So first, you identified Italian individuals, correct?
Yes.
And with respect to who you deem the Italian individuals, you've noted already today that there is some dispute between the parties, who is Italian and who is not.
Correct.
Right? You were instructed to assume that certain individuals were Italian, correct?
I did my analysis assuming that claimants, individuals that they identified as Italian, were Italian unless there was a dispute between the parties. Or if I found that, for example, with Silvana or with there was the Bellas, there was another individual that claimant was counting as an Italian individual, but the shares actually belonged to someone else, not the Italian individual they were identifying.
And one person that you do not include is Renato Palazzo de Colle, correct?
Correct, and claimant does.
And you reviewed the share registries looking for those names, correct?
Correct.
And in doing so, you assume that the owner of the shares is the individual listed on the share registry, correct?
For that specific name, there's an issue, right? If you go to the exhibit, the share registry mentions Renato Enrique Antonio Palacio, but I think when you look at the shares, is Renato something Sacasa.
Yeah.
And then when you look at the board of directors, there's Renato Enrique Palacio and then De Colle, so they're two different individuals.
We'll come back to that specific company, but the assumption that you make is that the owner of the shares is the person on the share registry, correct?
On the which share registry?
The registry of the relevant entity.
Yes.
And as discussed earlier, you did not look to the other provisions of the corporate documentation regarding shareholders or their rights, correct?
Correct.
An example, perhaps, of this last point would be if you were to disregard category E, which is all the trust documentation, correct?
Yes.
Okay. Now let's go to Liguria. But first, I'd like to sort of put up table 3 in the detailed view, and this is the IK tables exhibit. Now, just to clarify, Ms. Kunzman, that is your exhibit, right? IK being your initials?
Yes.
Okay. And if we look here, this is tab 3 of that document, and I think we should go back up for just a second, just to clarify what this is. This says figure 3, summary of ownership percentage under 5 scenarios, expanded, correct?
Yes.
Because the version of this that appears on page 8 of your report doesn't have the detail of the individuals in each category, correct?
Correct.
Looking at how this is laid out, the category on the left, what is in the Excel file B and C, those columns, is the names of the individuals and the categories they fall into, correct?
Correct.
Column D is then the share percentage in June of 2011, correct?
Yes.
Column E in August of 2014,
Yes.
and column F, the same information for May of 2020.
Correct.
I say those only because as we scroll, we'll lose the heading there that explains
right.
what they are. So if we could scroll down now to the end of C, and I'm going to be in line, I believe, 43. There we have Liguria Holdings SA, which is a Panamanian company, correct?
Correct.
And for 2011, in column D, you have NA.
Correct.
And for 2014, in column E, also NA.
Correct.
And I believe we got in advance of ourselves. You already explained that the reason that this company is here let's actually look at line 46, where it does appear. In line 46, you have the percentage for Liguria Holdings for each of those 2011 and 2014, correct?
Yes.
And the reason that it's there under firms with disputed Italian ownership in those years is that the shareholder listed is Rogelio Palacio.
Right.
Okay. And you noted that basically, in paragraph 24 of your report, that basically category D is companies in which Rogerio Palacio is the shareholder.
Correct.
Now, in figure 17 of your report, and I don't think we need to put that up right away, unless we have a question, you include there the constitutive documents of Liguria among what you reviewed, correct? Figure 17 is the
Yep.
very end, yeah, it's page
Correct.
36 of your report. Okay.
Yes.
Sorry, your question and you're overlapping just a bit. Figure 17 is the very end.
It's the very end of your appendix 4 and appears on page 36 of the report, correct?
Correct.
And if we look here at Liguria Holdings, it's toward the end. We have as the share registry, you reviewed document CDP 0210. Is that right?
That's right.
And I can represent to you that that exhibit is in the record as exhibit R-23. Does
Okay.
that make sense? We'll put it up and you can verify it's the same document that you reviewed. If we go into R-23, and you noted in your table 17, which I believe you still have open, that the pages you reviewed were page 30 to 34 for the share registry. Is that right?
That's right, of the PDF.
Okay. And I believe on the exhibit version of the PDF, that's actually now 31 to 35 because there's a cover sheet.
Okay.
Does this, before we scroll, is this the same document that you reviewed as CDP 0210?
Why don't we just put in CDP 0210 to make it easier?
The CDP numbers are not in the case file, which is
okay.
why I've put up the exhibit version.
Okay.
But I can say for the record that if we look at the consolidated exhibit list on page 54, R23.SPA has as its title, Liguria Holdings Constitutive Document produced as CDP 0210.
Got it. Okay.
So if we go back to R23 on page 31, is this the shareholder registry that you reviewed?
Yes.
And here we have Rogerio Palacio de Colle, correct?
Correct.
Okay. Are you, in reviewing claimant's rejoinder, are you aware that Renato Palacio Sacasa has put in a witness statement in this case?
Renato Palacio Sacasa. He has an affidavit, right?
And he also, with the rejoinder, put in a witness statement.
What was the exhibit number?
It's a separate document. It's a witness statement. If you did
Okay.
not review it, I don't want to put it to you. I'm sorry, we crossed.
Yeah, you're overlapping.
Por favor. Gracias.
Of course.
I can't tell you whether I've reviewed it or not without looking at it.
Okay. I won't put it to you. I just wanted to know whether you had seen it. So, am I correct that Liguria Holdings appears in category D in your figure 3 as disputed because the shareholder listed here is Rogerio Palacio de Colle?
Because his passport that's towards the end of this document shows us expired in 2005, his Italian passport.
If he were not a disputed Italian, as you've defined those in category D, do you agree that Liguria Holdings would appear instead in category C in your table 3? We should go back to table 3.
If he were not a disputed Italian, it would appear in C, yes.
As it does, in fact, in 2020.
Correct. But in 2020, it is because the ownership changes. So,
I've put table 3 back up from the Excel version, and here you can see at the end in line 43, Liguria Holdings in category E, in column F, has the percentage listed there. So as of 2020, you consider it a firm with majority Italian ownership, correct?
because the ownership changed from Rogerio Palacio to Renato Enrique Antonio Palacio.
And so, in fact, if you change other assumptions in your model, whether you're looking at the Italian identity of the person, the percentage that you calculate of ownership overall would move from category D to category C, correct?
If there was no dispute for Rogerio Palacio for 2011 and 2014, those percentages would move to category C, yes.
All right, if we could go back just to, very quickly, the construction of your model. Step 3 was standardize the names.
Yes.
Right? Step 4, you determine the total shares outstanding of each company, correct?
Correct.
And here, you note in your report, in paragraph 20, we should hold off, that in most cases, and you repeated this again in your slides, you found the shares outstanding from the share registry, correct?
Correct.
And when you say that you found them within the share registry, what do you mean by that?
That the total shares outstanding were in the share registries.
Is it as a reflected number in the registry itself, or are you doing the addition of issued shares? Sorry.
I did both. In some cases, I had to do both to check. Sometimes they were shares that were issued, but, authorized shares, but not all of them were issued. There were some instances where that happened, so I had to dig in a little further.
And in determining which shares were issued, did you do that by reference to the share registry?
It depends on the case. Yeah, it depends.
And so you did note in your report that you understand the number of shares authorized may be different from shares outstanding, correct?
Correct.
I have no further questions, Mr. President.
Thank you, respondent.
We don't have questions. Thank you.
No questions for the tribunal, so Ms. Guzman, you're free to go. Thank you very much.
You're welcome.
So where are we with the next expert?
I believe Mr. Flubacher is still in the train. I think he's scheduled to arrive at Union Station at noon. If it would be possible, maybe we could start with Mr. Olson.
So he'll be here. Okay. How long do you expect both parties, because we have two experts left, the two experts in Delaware law, and it would be ideal, if possible, to hear both today, because to be able to contrast each other. So would you think that's possible if he arrives at noon and we start around, I don't know, 1:30? Could we be done by the end of the day with the two experts? Claimant, what you?
Absolutely, Mr. President.
For sure, yes.
Okay, so let's break now and get back at 1:30, and we start with the two experts on Delaware. Thank you.